Welcome to Details in Divorce, where we break down the legal, financial, and emotional aspects of divorce to help you make informed decisions. I'm your host, Paul Riley, and each episode we dive into key issues that impact individuals who are navigating separation and divorce. So, whether you're concerned about asset division, protecting your business, or dealing with high conflict disputes, we are here to provide clear and practical insights. Now, divorce is complex, but understanding your rights and options can make all the difference in the world. And while this isn't legal advice, it is designed to empower you with the knowledge you need to move forward with confidence. Well, let's address a recent Ontario Court of Appeal decision that reinforces how courts decide parenting time and decision-making authority, especially in high conflict cases. The case is S.R.I.S v. N.Z., decided in 2025. At its core, this case reminds us of something family courts repeat often but apply very carefully. The only consideration is the best interest of the child. It's not about fairness between parents, not cultural expectations, not what the parenting arrangement used to look like. The parents, in this case, married in 2009 through an arranged marriage and separated in 2017. During the marriage, they had 2 children. Initially, in 2019, the court ordered shared parenting on a week-about schedule, meaning one parent has the kids during one week, the other parent would have the kids during the following week. But over time, conflict between the parents escalated. And critically, that conflict began to negatively affect the children. So the mother brought a motion to vary or change or alter the parenting order. The father responded with a cross motion of his own. After hearing the evidence, the trial judge did in fact vary the initial original order. The children were now to live primarily with the mother. The mother was granted sole decision-making authority. The father received regular parenting time, and travel outside Canada was restricted. The mother also required to consult with the father on major decisions. The father wasn't happy with this, so he appealed. And the Court of Appeal was asked one main question in this case. Did the trial judge make an error in granting the mother primary care and sole decision-making authority? Well, the Court of Appeal responded with no. The court reaffirmed that when deciding parenting issues, courts must consider only the best interests of the children as set out in the Divorce Act. In high conflict cases, this involves assessing credibility, weighing competing narratives, and making fact-specific findings about what arrangement best supports the children's well-being. This is primarily a factual exercise, and appellate courts show strong deference to trial judges who have heard the evidence firsthand. The Court of Appeal emphasized several key findings that supported the trial judge's decision. First, the mother was found to be more likely to support the children's relationship with the father, and that's critical because the law dictates that kids should be with both parents equal time. If it's a high conflict situation like this, and one parent's going to be the primary parent, the court still wants to make sure the other parent plays a role. In this case, they felt if dad had primary parenting, he wouldn't foster a relationship with the mother and the kids. In fact, the court said, contrast, the father attempted to prohibit, in this case, a relationship between the children and someone close to them without a child-focused justification. That weighed against him. As I stated earlier, it's imperative that both parents are involved in some capacity. Second, availability mattered. The mother was available to care for the children during the week and on weekends. The father's work schedule meant he relied heavily on another caregiver. What the judge in this case found that was not optimal for the children, given their needs and the level of conflict in the case. Third, and most importantly, the trial judge found that the father continued to engage in culturally specific domestic violence against the mother. That finding was significant. The Court of Appeal made clear that domestic violence, including non-physical, culturally contextualized forms of control or coercion, is directly relevant to parenting decisions because of its impact on safety, emotional stability, and the children's overall well-being. Taken together, these findings supported the conclusion that it was in the children's best interest to live primarily with the mother, with the father having structured parenting time so he would have access as well. This case also provides important guidance on decision-making authority. While courts generally prefer shared decision-making where possible, this case confirms that high conflict can make shared decision-making just unworkable. Here, the trial judge found that granting the mother sole decision-making authority while still requiring consultation with the dad was the best balance. The need for stability, the need to reduce conflict, and the children's long-term interests. So the Court of Appeal agreed with the trial judge in this case. The Court of Appeal dismissed the father's appeal because the trial judge applied the correct legal test, in their estimation, and made detailed factual findings and grounded the decision squarely in the best interest of the children. This was not a case of preferring one parent over the other. In fact, it was a case about which parent was most likely to promote stability, reduce conflict, and support healthy relationships with the other parent. The appellate court would not reweigh the evidence. The takeaway in this is then very clear. Parenting decisions turn on the children's best interests, not parental entitlement. In high conflict cases, courts will prioritize stability, safety, and the parent most likely to foster healthy relationships for all involved. And once a trial judge makes careful child-focused findings, appellate courts will rarely and reluctantly interfere. This case is an important reminder of how Ontario courts approach parenting disputes and why evidence, conduct, and child-focused decision-making matter at every stage. Well, that's it for this episode of Details of Divorce. We hope you found today's discussion insightful and valuable as you navigate your own divorce journey. Remember, every situation is unique, and getting the right information is key to making the best decision for your future. If you have any questions or need guidance, the Riley firm is here to help. Be sure to subscribe so you don't miss our upcoming episodes where we continue to explore the critical issues that matter most during divorce. I'll see you next time.